Mawakiri munini wa mutongoria wa bururi Muhagũre Rigathi wa Gachagua nimonekete kwaga kwiganira thutha wa kwirikana ndudu ya majaji atatu iria yombirwo ni munini wa mucirithania munene Philomena Mwilu ndiri na ukinyaniru amu kiwatho ndudu iyo yagirirwo kumbwo ni mucirithania munene Martha Koome.
We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, your lordships, on 165 clause 4 on the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, your lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, your lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 plus 4? What was the necessity of the delegation of this function? Those are pertinent issues, your lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, your lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice.
Makirehe gicajama mawakiri a Gachagua maugite kihoto kiao kiaya kwagararwo kuna itua ria guthikiriria cira uria kinyanirio muthenya wa Juma utuku na kuria maugite ni mugaru na watho wa gatiba ka 2010.
That you are convened by the Honorable Lady Justice Will, the Deputy Chief Justice. Well, but what's arising from that are one, a legal issue and a matter of Article 150. But under the law, and we do this every day, I practice public law every day.
The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemably. And I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordships, your leadership should, on the basis of those irregularities, down your tools. There is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday.
Mwena-inĩ wao majaji aya atatu nimeteteire na kuga cira uyu uratwarithio kuringana na watho na hatiri handu magararite gatiba ya bururi.
There are articles of constitution of this bench in the record. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Handu-inĩ ha Kiambu TV, o nĩguo gũtariĩ rĩtwa rĩakwa nĩ Waithĩra wa Mwangi.